Abby Finkenauer didn't have any thoughts to share as she walked out of the Iowa Supreme Court building this afternoon. The justices had just heard her case about whether she has enough valid signatures on her candidate petitions so that she can be included on the Democratic primary election for the United States Senate. She's trying to take on Chuck Grassley. The Secretary of State's office requires 3,500 valid signatures for the candidate running for the U.S. Senate. Finkenauer's campaign collected nearly 5,000. But her legal case and the campaign's future comes down to just 3 names on these pieces of paper in question. Political Director Dave Price sat in on the hearing today. He joins us now. You've broken this down accurately by stating that it really comes down to where the signatures weren't gathered or were gathered. That's up for the justices to decide, right?
The blank spots there.
Sure.
And to set things up, I think this map will kind of keep it all in perspective. So they have to collect 3,500 valid signatures so that they can qualify to get on the ballot if they're running for the U.S. Senate. But it gets more specific than that. You have to get at least 100 signatures in at least 19 counties, so keep those in mind. Now, her problems are with 2 counties in particular, Allamakee and Cedar County. And just to remind everybody, in Allamakee, there was 1 signature where it did not include the date. In Cedar County, there were 2 signatures that did not include the date. So if those are not allowed, she falls below the thresholds in both of those counties. So then she falls short. She can't get on the ballot. That's really the crux of all of this. So they have their chance to go to the Supreme Court. Both sides get to lay out their cases. And I want to show one exchange in particular between one of the justices talking about how these signatures work and should you have the date filled out and should you not? Here's his hypothetical.
Let's assume the campaign decided they weren't going to collect any dates at all. And as I understand your position, that's fine, because the exclusion statute says that those signatures can be counted. So you could have an entire slate of 3,500 plus names and no ability for the state to determine whether these people were eligible electors. Is that your position?
I think the interpretation of the statute, which is the fairest interpretation of the statute, could allow that. Now, a couple caveats to that. First of all, if a campaign did that, and if a date was necessary to determine whether a signature line was valid, if a challenge was made, this person, at some point in time, was not eligible, and it depends upon, having a date, that would be a non-eligible signature is a reason that the signature line can be invalidated, and not having a signature there may have consequences that could result in that signature line being invalidated.
Legal arguments here. So this is how some of this went here. So, and to back off here a little bit of perspective here, Dan, because you brought up a good point here as we were listening to Sam Langholtz. So from Finkenauer's side, if you will, she had sort of 2 attorneys. Sam Langholtz is an assistant attorney general. He is technically there representing that state objections panel that we followed a couple of weeks ago. And remember, you had 2 Democrats, including the attorney general, and 1 Republican. Yeah. They said the signatures should count even though they didn't have the date. Then Abby Finkenauer herself also has an attorney there. So that's where it gets, you get funky, follow the legal arguments here about the signatures. So Sam Langholtz is saying, yeah, maybe if a campaign decided don't even worry about the dates, even though they're supposed to be on the form, then yeah, maybe they should still be okay. And then, so that may raise some flags there.
People arguing the opposite day.
That's right. So on the other side, these 2 Republicans who have objected to all of this, so their attorney got his chance to argue here. Now, one of the things he had to deal with, and we'll let you hear from him at 5 o'clock tonight, is that legally speaking, the question came up about, okay, fine, how are these 2 Republicans injured by this? Why should they be the ones to challenge all of this? And he's saying, well, basically that the legislature gives everybody the right to make sure we have a fair election process. I'm really oversimplifying
Yeah.
all of this because
Like a legal
clearly-
argument for no harm, no foul. Pretty much.
Exactly.
Dave, I know there's a lot more to break down as we're going to
And
go
we
through
don't
the
know a
rest of the evening
timeline here
shows. Yeah, exactly.
for a
And-
decision.
And they got to do it quick, though. That
sure.
primary is coming up, and it would be overturning what a judge has already decided to.
Correct.
We're back with Brett's Full Forecast.